Let's go. Good morning. Y'all bow with me, please. Gracious Heavenly Father, as we start a new week, please be with us, guide us, keep your hand on us. Let us do things that are pleasing to you and are pleasing in your sight. Lead, guide, and direct us in our daily lives. Let us remember that all things come through you. In Jesus' name we pray. Amen. Y'all, we're going to have to hurry. We're going to have to hurry, Wall. I don't know where I am. Which one is it? Mr. Watson.
Thank you, Mr. Chairman and committee. I bring back to you House Bill 147. This originally, when I presented, had two things in it that it does not have in it now. It does not have the shall and will that the Composite State Board of Medical Examiners had asked for. That was beyond the scope of this bill. And I also took out the retirement portion since that actually was covered in another place. So basically, House Bill 147 is an amendment to Patient Right to Know Act of 2001. It asks basically two things. It lists whether or not a physician has medical malpractice coverage insurance, and that will be a question in one of the 20 questions that will be asked. And then it asks the Composite State Board of Medical Examiners to collate and get back to us once a year, basically that information.
Any questions? Thank you, Mr. Watson.
Thank you.
Good morning.
Mr. Welch, just jump right up there.
Yes, sir.
Ready to begin.
Yes, sir. Thank you, Mr. Chairman. My name is Andy Welch. I have House Bill 339 before you. This is a bill that made it through the House and then over to the Senate and died for lack of time in the Senate last year. This amends Article 3, Chapter 3 of Title 38 relating to the emergency powers of the governor and the judicial branch. This streamlines appeals, identifies the proper venue for appeals of vaccination and quarantine orders, streamlines the appeal process. It also sets forth that the emergency powers of the judicial branch would be that same time period as set by the governor. These are modifications to the existing law, and that's as brief a summary as I can give you.
Questions? Thank you. Mr. Atwood.
Thank you, Mr. Chairman. Members of the committee, I bring before you for your consideration substitute House Bill 261. It's an amendment to Code Section 501872, which relates to when public disclosure of public records are not required, relating specifically to those records, the disclosure of which would compromise security against sabotage, criminal, or terrorist acts, and the non-disclosure of which is necessary for the protection of life, safety, or public property. Specifically, what we seek to add is one paragraph: records of any government-sponsored programs concerning training relative to governmental security measures which would identify persons being trained or instructors, or would reveal information described in previous subsections that are already Georgia law, that being security plans, vulnerability assessment for any public utility, any plan for the protection against terrorist or other acts, and that sort of thing. We have worked very closely with the Attorney General's office on this. Our language mirrors theirs. The upcoming changes that they're suggesting. We've also worked with the Georgia Press Association as well as the First Amendment Foundation, and they're happy with it. That's essentially it, Mr. Chairman, members of the committee.
Got questions? Let's see. Mr. Weldon.
Thank you, Mr. Chairman. Representative Atwood, is it not true that this legislation you bring before us today is in response to requests by certain groups that may or may not be connected with terrorist organizations in order to protect those who've received training to counteract their work?
Yes, sir, it is. Some of the folks that testified for us were folks like Lieutenant David Barnes, who's a SWAT team commander with Dunwoody Police Department. We do have initiatives under the Gilly program, which relates to grants which will allow police officers to go over and study anti-terrorism in Israel and other places. And we live in a global world, and there's dangers there, and this is simply to protect them as well as the instructors that teach them.
If I could, Mr. Chairman.
One more.
Is it not true that you've had open records requests for the names of these actual individuals who have gone and received training to get their names so they could potentially target these law enforcement individuals?
That is true.
Thank you.
Any other questions? Thank you, Mr. Atwood.
Thank you, Mr. Chairman, members of the committee.
Mr. Ramsey.
Thank you, Mr. Chairman. I'm asking for HB 47, which you will find on page 1 under modified structure. This is the same bill that we passed out of the House last year that will allow Georgia insurance companies to sell insurance products that they also sell in other states. It has all the same consumer protections that we put into it last year that ensures that Georgia insurance consumers have access to Georgia courts and access to the dispute resolution process afforded them through the Insurance Commissioner's Office. We believe this is the very best thing we could do as a state to give the 20% of our citizens that are uninsured access to health insurance, and would be happy for any questions, Mr. Chairman.
Any questions? Minority Leader.
Thank you, Mr. Chairman. Mr. Ramsey, does this legislation require that any policy sold in Georgia comply with the existing mandate policies in Georgia, including coverage of mammograms, coverage of other coverage of days of stay for pregnant women? Does it require that any policy sold here have to comply with our existing mandate policies?
No, it does not.
Thank you.
Any other questions? Thank you, Mr. Ramsey.
Thank you.
Mr. Dixon.
Thank you, Mr. Chairman. I have 3 one-page bills, if I may. First is House Bill 125, which you had heard previously. I brought it back to you with the changes that I think were requested. It reinstates a sunset date of 2016, dealing with the Agriculture Education Advisory Commission. Would appreciate your support of that.
Let me do them one at a time, Mr. Dixon. Has anybody got a question on that? Go.
Next bill, House Bill 205, which is also in the modified open rules section. Excuse me, House Bill 205 is to extend lemon law protection that private citizens have to vehicles purchased by governmental units. For instance, if we buy a state patrol car and it turns out to be a lemon, we don't have that same protection that you would have as a private citizen, and that is the extent of House Bill 205.
Any questions? Go.
The final one is House Bill 314, which is in the modified structure rule section. It's entitled Jesse's Law. It deals with children who are in a foster care situation. When they are called to court regarding that foster care situation, this bill would extend to them the same kind of protection in terms of their attendance at school as a page enjoys when they are here. It was brought about by a student who had maintained perfect attendance for several years, was called into court for something related to their foster care status, and lost perfect attendance for that year. This would protect those students.
Any questions? Thank you.
Thank you.
Mr. Geislinger.
Thank you, Mr. Chairman. I bring before you House Resolution 186. You'll find it on page 2 at the very bottom. This is a piece of legislation that will amend the Constitution after a vote of the public for pari-mutuel wagering on horse racing. If you will look at the legislation on the back side, you will see that it is for educational grants, scholarships, and loans, voluntary pre-kindergarten and for trauma care for public and private hospitals. This is privately funding, and the enabling legislation has been introduced, and it is House Bill 467, if you would like to look at it. If there are no questions, Mr. Chairman, I will.
Do we have questions? Thank you.
I ask for your favorable consideration. Thank you.
Mr. Jacobs.
Thank you, Mr. Chairman, members of the Rules Committee. I come to you with two requests today. The first is actually to recommit at the appropriate time House Bill 62 back to the committee from which it came. And that's to fix the first-class mail issue that we discussed at the last meeting. And the second is to present House Bill 110. House Bill 110 deals with an issue that local governments have been dealing with on their own, and that is who owns a piece of property for code enforcement purposes after the property has been foreclosed or if it's vacant property. The problem that is presented is that we've had at least 9 jurisdictions with a couple of other major ones, including Gwinnett County and the City of Atlanta, set up registries where they're all collecting different information about who the owner of the property is under different standards, charging different fees and different penalties. And the more and more this is done across the state, the more it's going to be a logistical nightmare for particularly the banks that have to file these in a number of different local jurisdictions across the state, including some of the largest jurisdictions in the state. What the bill does is sets forth uniform standards for maintaining these registries. It standardizes the information that can be collected, meaning we're saying you can only collect the information that is set forth in state statute. It caps the penalties and it caps the fees. The other thing that the bill does, which I kind of like, is there in subsection E. It says that if you foreclose on a piece of property and you include the particular information that is called for in this statute on the deed under power or the deed or a deed in lieu of foreclosure, you file that within 60 days and you provide proof of that to the local government, you are exempt from any filing requirement with the local government, meaning the state has an interest in making sure that title to these properties is perfected in a timely manner, and if the banks go ahead and do that and they've included the information that the local governments want anyways on their deed, then they're exempt from any local government requirement to file the deed. And the last thing is, this probably isn't out yet, but there is a technical amendment that will be presented by Chairman Willard at whatever the appropriate time is, and that is to fix kind of an odd double negative that was created on lines 21 and 22 by virtue of an amendment that was done very quickly at the very end of the last full Judiciary Committee hearing on the bill.
Any questions? Chairman Smith.
Thank you, Mr. Chairman. Thank you for bringing us this bill. I think it's something that we need. I'm just trying to clarify a couple of things.
Certainly.
We're mainly talking about property that goes back to banks. Is that correct? In foreclosures, or are we talking abandoned property that they've just left, and what happens?
Both.
Some have loans, so is that clearly delineated in the bill?
It's both, and it's all contained within the definition of vacant real property. We're defining that as, in essence, vacant real property or foreclosed property. The issue is this. Local governments are setting these up both ways. DeKalb County has a foreclosed property registry. Gwinnett County, 2 huge jurisdictions in the state, is looking at a vacant or abandoned property registry. Right. So we're saying that if you're doing you can do either one of those, but you've got to collect the information, the same information, and the same standards apply to either one.
Okay, so we've covered everything. All right, thank you.
We've covered all the bases.
Mr. Weldon.
Thank you, Mr. Chairman. Mr. Jacobs, or Chairman Jacobs, isn't it true that this is a bill that straightens out some things and puts uniformity to how much a county or municipality can charge as far as the amount for registration, and in addition, it also addresses penalties?
Yeah, that's correct. And it preempts the existing local ordinances. It says that if you're going to do this, you have to do it in accordance with the state statute.
One further short question, Mr. Chairman. Mr. Chairman, is it also true that we had counties or municipalities in this state that were charging $1,000 a day as a penalty for failure to register the property down to much lesser amounts?
That's correct, and it's capped under the bill.
Thank you.
Thank you, Mr. Chairman.
Mr. Davis.
Thank you, Mr. Chairman, Madam Speaker, and members of the committee. I've got 3 bills that I'd like to ask for today. The first one's at the top of page 2, House Bill 167. This is my second time asking for this. We sent it back to Insurance Committee for a technical amendment in the drafting of an amendment in committee. So this is the Insurance Delivery Enhancement Act. It includes some market-based solutions for small businesses to pull together and reduces some of those regulations, and it also has prompt pay statutes for third-party administrators. And I already presented it once. I could go through it a little bit more specific if you'd like.
Nope. Any questions on 167? Next one.
All right, my next one is at the top of page 3. Might be a little unusual at the timing of this, but Senate Bill 38, the Majority Leader, Chip Rogers' bill dealing with the superintendent powers of the state school superintendent. And basically why we're asking for this now is the governor has just recently appointed his new board, and these are some of the adjustments that the governor would like to see, and as well as the Majority Leader. And basically what we're doing is we're going to allow the state school superintendent to set the agenda for the board meetings, as do most superintendents in the state of Georgia. He will be able to hire and fire at his leisure, because even in current law, he is the chief executive officer of this department. And also we're raising the limit on the amount of contracts that he can enter into without board approval from $50,000 to $250,000. I'll get a question, I'm sure, about why we're making that raise. All the other constitutionally elected officers have no limit. I originally thought that this was bringing this in compliance with all the rest of them, but it's just merely raising them up. This only impacts about 12% of the contracts that they do are over $250,000. So.
Questions? Next one.
Thank you, Mr. Chairman. And the last one is, I'm a second signer on. It's House Bill 186. I just want to put my weight behind that. That's an education bill dealing with pathways. It's on page 1 in modified open. I'm sorry, I should have said that first. But Representative Nix and I co-chaired a study committee over the summer. We put a lot of heart and soul into that bill. It is supported by the department as well as GAE and PAGE. It's a common sense bill that gives some students opportunities for some educational choices within the public school system.
Questions? Thank you.
Thank you, Mr. Chairman.
Mr. Clark.
Morning, Mr. Chairman and committee. I've bring before you a substitute to 227, and it already cleared rules, but we had a suggestion, and we went back sent it back to committee, and the change is just a simple change to just a couple words. A quick summary: this bill just gives immunity to school personnel to administer an EpiPen in the event of shock or a child may die. Just a couple words were changed just to say any school personnel who in good faith administers or chooses not to administer, just to make sure that there is immunity on both sides. That is the only slight change to this, and I ask for your favorable consideration.
Any questions? Thank you. Members of the committee. Mr. Bearden.
Thank you, Mr. Chairman. On page 2 under modified structure, House Bill 414. This bill will allow the public safety portion of the GAA, the Georgia Aviation Authority, to go back to where it was before the creation of the GAA, and that is under the direct control of public safety. Right now, the Aviation Authority cannot do a public safety flight without the operation of a Georgia State Patrol pilot. That's all the bill does, and allow our State Patrol to fully do their duty they are charged with doing. Thank you, sir.
Mr. Rice.
Thank you, Mr. Chairman. I'd like to ask for HB 59, which is the lawful presence verification for post-secondary education benefits today. I've explained it once before. Also, I'd like to ask for HB 269, which is the departmental bill, cleanup bill, which also includes some increases in the fees for some of the driver education courses. Most of it the customer gets back in terms of insurance write-downs and things like that in terms of their discounts. So it's fairly innocuous. HB 309 I've explained before, and HB 198.
Anybody got questions of Mr. Rice? Ms. Sheldon. You know, it's amazing that we fix Cooper's and yours quits.
Is that better? That's okay. Thank you, Mr. Chairman. Today I bring back before the committee House Bill 226. This was a bill that creates individual savings accounts, individual development accounts for individuals low income and disabilities. This bill, I discussed it last week, and it I failed to mention that it passed out of the House and the Senate last year. We ran out of time for it for some changes. The other bill I bring before you today is under modified structure rule, House Bill 302. This is the bill that Secretary of State's office brought to us. You know, historically, whenever for elections following a reapportionment, the primary is held at a different time, and we have to make an adjustment to that to ensure that we remain compliant with the MOVE Act, which ensures that our military personnel will have absentee ballots are sent out at least 45 days prior to the election.
Any questions? Ms. Cooper.
Mr. Chairman, I'd like to ask for House Bill 147. That's the one where we find out how many doctors in the states do not carry insurance, liability, malpractice insurance, and House Bill 227. That's the one where epinephrine can be administered in an emergency situation.
Mr. Earhart.
Thank you, Mr. Chairman. H.R. 248, under modified structure, it's a resolution that effectively makes a statement that funds available, we will restore the funding for the National Board of Certified Teachers.
Okay. Mr. Willard.
Thank you, Mr. Chairman. I have two. First is House Bill 256. This is a bill that deals with the 911 systems and primarily with the oversight, collection, and distribution of what we call the prepaid amounts that are not now being properly collected and distributed to the local 911 systems at the county and city level. What you have as the money's come in, it's not distributed. It's been used in the past at a state level, just going into general funds. So this is to provide for a distribution which amounts, we think this past year, about $8 million that should be earmarked and is paid for 911 services. What happens, people will buy minutes. A lot of us who have telephones, cell phones especially, don't have a service provider. What they do is go in and buy minutes, a block of, say, 100 at a time, and they pay 75 cents for 911 systems. This is to make sure that money does come down. It's based upon a distribution of population of those 911 systems in the state. So what you'd have is a big pie and different slices coming out based upon your population as it compares to all the populations on the 911 system.
Any questions? You got one question.
Representative Willard, does the money go where the person purchasing the 911?
Good question. It does not. And the reason it's hard to pin it down, but secondly, people will buy the minutes many places. You may go into a convenience store somewhere where you just are not resident in that area. So we felt the appropriate way to do it would be based upon a division among all the providers by their population.
Thank you.
I also have another bill, I'm sorry, Mr. Chairman, House Bill 180, which is adding to what we call the rules of the road, the 3-foot clearance for passing of a motor vehicle on to a bicycle, and this is requiring the bicycle to be as far to the right as it can be, and then the passage would provide for a 3-foot clearance. We had the bill, I think, last year come up to this committee.
Any questions? Mr. Mitchell.
Thank you, Mr. Chairman and members of the committee. I direct your attention to House Bill 374 under modified open rule on the first page. Simply put, this truly is an innocuous bill. It is supported by the Secretary of State. In fact, it just simply, at present, there's a bifurcated process in securing a cosmetology license, a practical exam, as well as some experience. At present, with the cosmetology license, you could conceivably take the cosmetology exam 2 or 3 decades ago, and then now just get some serve under an internship and get your license. In the interim, the board has added requirements that you learn some disease detection and some other health issues that those who fall under this category escape. And this certainly just places everyone under the same guidelines in the department.
Any questions? Okay, Mr. Walker. Oh, did you have a question, Mr. Bearden?
I did, Mr. Chairman.
Please.
Representative Mitchell, I talked briefly before. This opens up the continuing education for cosmetologists. Would you have an issue, because right now if a cosmetologist goes out of state for training, that is not allowed continuing education for the state of Georgia?
We've talked about that prior to, and I certainly would have no problem with that. It seems to be uniform with every other certification process. That would be fine with me.
Thank you, sir. That would help out our cosmetologists very much.
Now, Mr. Walker.
Bill 271, which is the Georgia Student Extracurricular Partnership Act. This would enable a public school student to go to a public charter school and participate in extracurricular activities. It would also enable that public charter school student to go to the public school of their attended zone and participate in extracurricular activities. It is all subject to the discretion of the local principal and in accordance with local school board policies. So we had several subcommittee hearings on this, worked out a number of different issues, and finally came out of House Education with a unanimous vote.
Questions? Thank you. Mr. Lindsay.
Thank you, Mr. Chairman. On behalf of Chairman Golick, I'd like to ask for House Bill 181. House Bill 181 provides parents the opportunity to apply to the state school board for a waiver based on medical circumstances of the 1-year school enrollment requirement related to special needs scholarships. Such applications would be considered by the board on a case-by-case basis according to board rules and procedures.
Questions? Thank you. Mr. Roberts. Mr. Smith.
Chairman, I'd like to move on House Bill 248 on the modified open rule. It's the Healthcare Sharing Ministries Freedom to Share Act. I'd also like to move on House Bill 47 that Representative Ramsey just presented on offering accident and sickness policies approved in other states. And also House Bill 167, the Insurance Delivery Enhancement Act, presented by Representative Davis this morning.
Mr. Secretary.
Thank you, Mr. Chairman. House Bill 158, which is under the structure rule on the third blue sheet. This deals with nonpartisan elections. It would simply, this is something that came as a result of a request from counties. You know, in my county, we had nonpartisan election of judges after our general election this past time. In many counties across this state, we had very, very low turnout, sometimes 10 to 12 people coming to a precinct in races that are very, very important. They give interpretation of the laws we pass in some cases. And comes a request of local communities. It'll be a savings. It would just say that they would qualify. If you're in a nonpartisan race, you qualify just like we do as state representatives. And the election will be held in the primary. And if there is a runoff, it would be in the primary runoff, and it would be decided then.
Any questions? Thank you. Minority Leader.
Mr. Mills, so just so I can understand, the nonpartisan elections would be on both ballots, but they would be during the primary. Can you talk to me about why we'd do it during the primary, not during the general, where you actually have the highest turnout for these elections?
Well, the reason is what I stated earlier, which is because of the runoff. When you have a runoff, like we had this past time, we had our judges running in a runoff and a very, very low turnout. It used to be in the primary about 6 or 7 years ago. Representative Willer's telling me 4 years ago. I'm not sure, but it used to be, and we changed it. And it seems that now there's a request to move it back. It's a savings to the counties because you're going to have a primary runoff anyway, most likely. But it's not always likely. You'll have a statewide general election runoff. I know in my county it saved probably about $50,000. Number of counties I've checked that had to do it, it's saved quite a bit of money. And the judges are supportive of it, and they want to get the races over with in July.
If I may, Mr. Chairman.
You may.
Well, additional follow-up in talking to judges around the state, they feel that when they are in the general election, quite frankly, their message is getting lost, and their races are getting lost with the up ballot races going on, and that being in the primaries, the judges feel that these races will get greater attention.
Okay. Mr. Rice.
Yeah, I have a question for Representative Mills also. Just look at page 5 of your bill. It says, this is by general law or local act, in nonpartisan election shall be printed on the official primary ballot. Is this only referring that code section to judges, or is it all nonpartisan races?
It's all nonpartisan races, and believe it or not, we have some people that show up at the polls. They don't want to vote Republican and they don't want to vote Democrat. They just want to vote in the nonpartisan races, so you have to have a ballot for them as well.
Ms. Smith.
My question is as with any change to our voting procedures, it's subject to the review of the Voting Rights Act, I believe. Is that correct?
I'm sure that's correct, but I do not speak as an authority on that issue.
Okay. I think that would help clarify some of the concerns, too. Thank you.
I'm sure since it was like this 4 or 5 years ago before we changed it, it used to be this way. I'm sure it was fine.
Thank you.
All right. Let's start. We had a request from Mr. Jacobs to recommit 62. Do I hear a motion?
Motion.
All right. We'll set the calendar.
No objection.
Do I hear an objection? Thank you. HB 60, modified structure. Do I hear a move? Any objection? HB 114, modified structure. Any objection? HB 158, structured.
Move.
Any objection? HB 1... Granted. Granted. HB 199, modified structure. Any objection? HB 216, modified structure. Do I hear any objection? Okay. Okay. But
Which one?
I have.
She had an amendment to this thing. Yes, you have to adopt an amendment before it's voted on.
Ms. Drenner, you've got an amendment to HB 216. Would you like to do it now? You're on.
Thank you, Mr. Chairman. I'll draw your attention to AM 360240 on your desk. The amendment simply changes the word majority to what would be a supermajority, in that 4 out of the 5 members of the PSC would be able to pick the next chairman of the committee.
Okay. Anybody got any questions of Ms. Drenner?
I have a question.
Okay.
Representative Drenner, is this, do you know the PSC or anybody, where did this originate from, I guess? What's the thinking behind why you want 4?
The testimony in the committee, Representative Mills, was that this process has been in place for the last 18 years, and there's some problems within the PSC members about who's going to be the next chairman. So you have a 3-to-2 split constantly, and so my thinking was it makes the committee more functional by having a 4-1 split, and that way they have to reach across their differences in opinions and select the best chairman, instead of allowing the other 3 members to continue to control the membership.
Just real briefly, would it not also lead to a greater chance of gridlock? We've seen some unintended consequences around the country when other similar supermajority measures are required. California comes to mind, for instance, in their ability to pass a budget which requires a supermajority of their General Assembly, rather than simply allowing a majority of the elected officials on the PSC to make that determination.
I recognize your point, Representative Lindsay. However, in my county, I've found that in many instances, due to other coalitions that form, that we have continual gridlock, and I would like to see the PSC rise above their differences and reach across their philosophical differences that they have right now and be able to work more closely together. And that's the intention of the amendment. I think the PSC is probably, in my opinion, one of the most important commissions in this state, because they do what? They set energy policy, And I need not say that I've been working on energy policy for, 11 years? And,
I've heard the speech, yeah.
Thank you. So I'm not going to go into that. However, I would say that my amendment only serves to be in the greater interest of the common good of the state of Georgia.
Mr. Chanel.
Thank you, Mr. Chairman. Representative Drennan, what would happen if you couldn't get a supermajority?
Chairman Chanel, I don't see how that would not happen. Somebody has to chair the commission, and therefore they would eventually have to have a supermajority. I don't see how that would not happen.
Okay. We've got an amendment offered by Drenner. It's AM 360240 for HB 216. All those in favor of that amendment signify by aye. All those opposed, same sign. No. No's got it. All right. Now that means I'm going to put HB 216 modified structure. Now do I have a move? Move. Any opposed? All right. All those in favor of moving on that one signify by aye. Aye. Any opposed? Ayes have it. HB 227 modified structure. Move. Any objection? It's HB 302. Any objection? That's modified structure. HB 315 modified structure. Any objection? HB 414 modified structure. Any objection? HB 186 modified open. Any objection? That's the calendar. I thought I said. What is 186? HB?
HB, yeah.
Yeah.
Will we meet again today?
Yeah, right. You said, we just said, yeah.
You can decide, but it's something to think on.